Hi, everyone. I'm Jeannie Fromer. I'm a professor of intellectual property law here and vice dean for university partnerships at the law school. And I wanted to welcome you to the first session this year of Respectfully Dissent. This is where you get to experience your own professors debating the most important current legal and policy issues. And just to give you some context for those of you who haven't been to this series in the past, 1Ls and whatnot, since the mid-1900s, US Supreme Court and state Supreme Court justices regularly started ending their dissenting opinions with "I respectfully dissent." And it was a way of disagreeing while also communicating to their colleagues and the public that while there might be a sharp disagreement on the legal issue at hand, they retain respect and cordiality to their colleagues on the other side of the issue. And so it's in that spirit that we have the Respectfully Dissent series. Your law professors here might sometimes have sharp substantive disagreements with each other, but we also like and respect each other and value having discussions when we have disagreements, and we will walk away, hopefully, with respect and admiration for each other and learn from each other, sometimes be persuaded by each other. So effectively, we can be on opposite sides of the V and be supportive at the same time. Okay. So that's about the series. Today's event is about originalism. In recent years, originalism has gone from an academic theory to a powerful frame of legal argument. It's important in many judicial decisions. Major court rulings claim to rely on original public meaning. Leading litigators seek out historical arguments to bolster their cases. And what we're going to do in this session is explore where this kind of argument came from and whether it makes sense. When does it make sense? And so I'm delighted to have two of my brilliant colleagues here today to discuss this topic. Immediately to the right of me is Mike McConnell. Mike is a visiting professor of law at NYU. He's also professor and director of the Constitutional Law Center at Stanford Law School, and was a judge on the US Court of Appeals for the 10th Circuit from 2002 to 2009. To my further right is Noah Rosenblum. Noah is an associate professor of law, but hopefully not for very long because our faculty voted him tenure yesterday. And we hope to have him for many, many more years to come. So many more fascinating aspects to their biographies, which I have no doubt will emerge during the course of the discussion, but I want to turn to that. So I'll loosely moderate a discussion with them, and we'll leave some time at the end for Q&A. So Mike, why don't we start with you to just give us an opening sense of originalism, where you stand on it.
Well, sure. But if just a point of personal privilege, I'm going to be leaving NYU next Tuesday. And I just wanted to say, since so many of my students and others are here and colleagues, what a pleasure it has been. My wife and I have both been welcomed here so warmly by both colleagues and students. It has been, between that and the delights of this great city, it has been wonderful. So thank you for the chance to be here. This is nothing like complimenting the crowd to get a bit of applause. This is the fourth time that I have done a visiting gig at this law school in the fall, and maybe not the last.
Hopefully not the last.
We'll find out. So where am I? Let me just say first a little autobiographical note about where I'm coming from with this, because I actually started doing originalist work briefs and academic work before originalism was thought to be a thing, before Ed Meese and my former boss, I clerked for Justice Brennan, the sort of the great opponent of originalism, before they'd had their exchange. And so I have worked out my views on originalism, not from reading Supreme Court justices or theory, but just from working through constitutional law. And I did it not for any fancy ideological reason, but because I think originalism, at least in a certain common sense form, is the most sensible way to approach interpreting a very old text. That words are written for a reason. They have their authority because they are, we the people do ordain this Constitution. That's why the words have an authority, and to interpret the Constitution as meaning something other than what they meant when they wrote those words, just to my mind, doesn't make a lot of sense. Now, I'm not going to tell you that that originalism provides all the answers, because I know that it doesn't. But it does provide a lot of answers, and what I'm really convinced of is that we shouldn't be doing constitutional law when we know that it's not what the original meaning of the words were. Sometimes there may be a range of possible answers. I think there very frequently are a range of possible answers that the text and historically understood leave open to us. I also think, and I'm not sure that, I think a lot of anti-originalists misunderstand this point. Originalism is about the meaning of the Constitution. It is not about what people 200 and some odd, 30 years ago thought about the various issues of the day. It's not about what did they think about abortion. It's not about what did they think about affirmative action or any of these things. It's about what does equal protection mean? What does due process mean? What does the executive power clause mean? And I just autobiographically, so you know the range of issues that I consider originalism valuable for exploring. I have written about racial segregation. I've written about free exercise of religion, establishment of religion. One of my most recent books was on the executive power under the Constitution. I've written about due process. I've written, contracts clause, takings clause. I've written a Ninth Amendment. Actually, my first time I was in this room, I came as I was jurist in residence when I was still a judge on the 10th Circuit, and gave a lecture on the Ninth Amendment in this room. And I find the historical method to be quite illuminating. And again, it isn't because it points to a specific answer in every case, but it is something that gives us a guidance about how to look for an answer. And I think the leading alternative, I'm not sure, Noah and I have really not talked about his theory, so I'm not really sure what he's going to say as the alternative, but the way I see it is that the leading alternative to originalism is for judges to tell us what they think they want the Constitution to mean, what they want it to mean, according to their own lights. And I don't make light of that. I was a judge myself. Judges are, experienced people. Most of them are very fair-minded. A lot of them, have really great ideas. But in the end, that's not what I think constitutional interpretation can be about. If I really thought that the principle of judicial review is based upon the superior wisdom of judges, I would not be an originalist. The reason I'm an originalist is that I think judicial review is based upon the authority of an actual written constitution that was created at a particular point in time with particular purposes and meanings. And I think we ought to stick to it, or we ought to get to it as closely as we can.
So it's really just such a treat to be here and to be on the stage with Mike. For those of you who haven't had the pleasure of taking one of Mike's classes, I just can't recommend being in dialogue with Mike enough. He's, as you've already seen, incredibly reasonable and learned and has just such a wealth of experience. So I really do feel like I'm speaking for the faculty when I say how grateful we are to have you here.
Thank you.
Mike is also wrong. So wrong.
Respectfully so.
Respectfully wrong. But to understand the ways in which Mike is wrong, I think we have to start by trying to locate the approach that he's laying out amid a broader world of originalism. So the kind of common sense originalism that Mike is elaborating has got to be the most defensible kind of originalism that you could have. And I don't want to shadow box, but for the sake of the students, I just want to take a second to distinguish a few other kinds of claims that people sometimes make and call originalism. So the first claim I just want to get off the table is that the alternative to originalism would mean ignoring the past or not caring about what the words of a text might have meant at the time that they were written. I am not aware of any theory of interpretation that is practiced by judges or that has been used by scholars that doesn't think that the meaning of a provision at the time it was drafted has some bearing on the meaning of that provision at a later date. The question is entirely what the relationship is between that meaning and the later interpretation. And at least historically, the main claim to originalism was not that it had some bearing, but rather that the meaning was dispositive. So the stakes of this conversation in some sense aren't should we pay attention to history or not, but rather what kind of importance should we attribute to the original meaning of a proposition at the time it was elaborated. Okay, that's distinction one. Distinction two, there are so many different ways of taking original meaning. And I have to say, it's such a pleasure not to get into that right now. But again, for the sake of scholarly integrity, it's worth flagging an evolution in the kinds of arguments people have made about what it means to look at original meaning. So when Antonin Scalia writes this famous article called Originalism, the Lesser Evil, he's got a functional argument for why we should attend to the original meaning of propositions, and it's about constraining judges, not super far from the point Mike was just making about the alternatives. We can get into that in a minute. But at the time Scalia is writing, it seems like he doesn't have a super concrete conception of what this original meaning is or where to find it. People sometimes call his approach original intent originalism because it seems like what he meant was you got to get inside the heads of the people who drafted it. There are some obvious problems with that. The meaning of a written proposition is not just what someone intends when they write it. That has hastened a transition to what some people call original public meaning originalism. I like common sense originalism more. What does the word mean? I don't know, man. Try to understand what people would have interpreted it to mean, what a reasonable reader would have taken it to mean. But you can see how this conversation can very quickly get quite nuanced. So for example, suppose that a proposition turns out to have been a term of art. Okay, does it matter if it was generally known to be a term of art? What if only the lawyers knew it was a term of art? If we're going to look to original public meaning, should we look to the meaning of the people who, as understood by the ratifiers, as understood more broadly? Should we do a corpus linguistics analysis to try to understand the term? Okay, so you can see that there are lots of little things there that we can get into. I don't want to dismiss those. Those are important, but they highlight that this is in no way self-evident, and depending on the approach you take, you're committing yourself to certain claims or propositions about the law. Okay, but that would be shadowboxing because that's not the argument that Mike was beginning to lay out. Mike's position, I think, is, like I said, the most defensible version. As I see it, there are a few different parts to it. One is, this is just what it means to start by interpreting an old text. If you don't know what it was meant to signify, you're just not engaging with its terms. The second related proposition is about the bindingness of the writtenness of the Constitution. And then there's another claim about what the alternative would be, and a suggestion that the alternative would have to be letting judges do whatever they want. Let me start with the alternative. So I don't think our only two options are either where a text has a clearly ascertainable original meaning, we follow it, or judges do whatever they want. When you read judicial opinions, judges clearly take a ton of other considerations into account in interpreting how to apply even the clear language of a text. And sometimes, if you have clear text, but it runs afoul of one of these other considerations, it might lead a judge to put a thumb on the scale around how to read it. So for example, if an interpretation of a proposition would be plainly unreasonable, Judges do that in the statutory interpretation context relatively frequently. We have the rule against absurdities. Then at a minimum, a judge is going to look really, really hard at the proposition to see if a more reasonable interpretation could be come up with. So why shouldn't that be something we allow when we read even a constitutional provision? Or consider questions of practicability. Suppose an interpretation of a provision would lead to a result that was unbelievably impracticable. A judge will routinely allow that consideration to inform how they read the proposition, even if we could clearly ascertain the meaning. Why wouldn't that be a legitimate consideration to inform our reading of a proposition? I'm going to go on, but I just want to flag how narrow the space is in which we're arguing. Right? We've already ruled out places in which the meaning isn't clearly ascertainable. So we're talking about either places where there's a clear meaning and the meaning is in tension with some other judicial value, or places in which, as Mike was suggesting before, a range of possible meanings have been allowed, and we're going to choose within that range. If we allow ourselves to let these other propositions weigh in, I think we're already moving away from some of the strongest claims of originalism, that all that constitutional interpretation is would be trying to ascertain the original meaning of a proposition at the time it was elaborated, and if we can, making that apply or bind us. One hypo that I was playing through with I'm teaching a class this semester on American legal thought. I see some of you in the audience. We were talking about originalism recently. One question that I was thinking through in my head was, what do we do about things like the constitutionality of the state of West Virginia? So the Constitution has a clear provision. In order to become a state, if you're being carved out of an existing state, you have to have permission of the state out of which you've been carved and of the federal government. That's in the Constitution. Okay, we could do an original meaning of that proposition. The problem that we have is that the reality of the creation of the state of West Virginia is that it's a product of the Civil War, right? Virginia secedes, they're traitors, but the loyalists in West Virginia secede from Virginia and join the Union and get recognized as joining the Union. The reality of West Virginia's constitutionality, I think, turns on the historical facts, the Civil War, the secession and reentry, not the original meaning of the Constitution. And if it turned out that the original meaning of that proposition was that the states needed to consent, which I think it was, and that Virginia didn't, which I think it didn't. You can come up with a legal fiction that they did, but that's BS. We know what happened. None of that changes the reality that West Virginia is constitutional. So I think if that's true, then even common sense originalism isn't something we can cling to in all times and places as a universal theory of interpretation. It's just one way of interpreting the Constitution among others. And sometimes it might be useful and sometimes not, which makes it the same as any other theory of interpretation.
So we may not be as far apart as the binary here implies, which is often true. I don't know how many times I've been in debates only to discover that the stark differences are not so stark.
This is profoundly reassuring for me because you don't want to disagree with Mike McConnell.
But I'm going to see if I can identify what we actually do disagree about and then talk about that a little bit. So Noah tells us that nobody thinks that the original meaning is of no importance at all. And then, and I don't, of course, I think that's almost true. Actually, there are some people who say that. Our mutual friend, Mark Tushnet, once said the Constitution should be interpreted in order to advance the cause of socialism, which I think is contrary to that. But what I think is it's not just that originalism should be taken into consideration. I think and it's not that it's the only thing, but that it does have priority of place. That is, in cases of conflict where you know what we do know about original meaning should trump the various considerations. So here's the way I look at like the whole process of constitutional interpretation is, of course, you begin with the text, and you begin with the text in its linguistic context, and then you look at its history, and I might say a few words about what I think one should really look at in that connection. But you look at its history, and it's going to tell you a lot. I mean, at least I have been able to find in my work, I've come to the conclusion that actually that reveals a great deal about some of the more controversial provisions of the Constitution. It's not all sort of vague generalities to be filled in. There's some real content, even to things like equal protection and free exercise. There's real content there, and I think that's binding. I do not think modern interpreters should be entitled, in the name of the Constitution, to say that the Constitution means something other than that. But when it leaves a range of possibilities, as it does, not infrequently, I think we then turn to things that are compatible with originalism, but are not originalism. And so the first two things that I would turn to, and it depends, we could have a long discussion about which one, but there's basically two tracks. Madison calls them both liquidation. And the two tracks are a course of decision-making outside of the courts, and then there's a course of decision-making in the courts. In the courts, we call that stare decisis, or precedent. Out of the courts, it has different names, but it's increasingly called something like custom and tradition. Sometimes it's called traditionalism, and this is where the court, and many cases like Noel Canning, and there are a number of cases. Bruin, I think, is like this, although I don't fully understand Bruin, but where you look at the course of interpretation of this idea over time, and so when a modern day judge looks back at precedent, that judge is not saying, what do I think? It's what have the courts said. And when the modern day judge looks back at custom and tradition, it's saying not what have the courts said, but what have the people through various Republican institutions like state legislatures and Congress and the executive branch and sometimes common law courts, what have the people said over time about this? And I think large numbers of cases are going to be resolved that way. If at the end of that, you've looked at history, you've looked at text, you've looked at liquidation, if at the end of that you cannot confidently say that what the legislature today has done is unconstitutional, to my mind, the answer is it's not unconstitutional. Now, Ronald Dworkin, whom I assume many of you have studied, kind of goes along with the first several stages of that, which he calls fit. I don't know why he insists on weird vocabulary, but he kind of goes along with that, although he never finds it binding in practice. But then he says, at that point, if there's not an answer to be found in one of these sources, that the job of the judge is to give the philosophically correct answer, to make the Constitution as good as it can be. And that's where I really draw the line. I think that is a mistake, because I don't think that I don't think there usually is an answer to that question. There usually, every important constitutional question has reasonable people on both sides of it. And to say that one of them is like the better answer than the other just because I think it's more persuasive, I think that abortion is perfectly okay. I think abortion is the taking of an innocent human life. Those are both reasonable positions, and I don't think that the judge is in a position to answer. Or my former colleague Richard Posner would say, not similar to Dworkin, but he'd say the judge should find out what's the most efficient answer to that question. And I don't say either of those. I say at that point, Democratic branches have done what they've done. It isn't unconstitutional, and we're stuck with what we voted for.
So I agree with Mike that the space between us is probably not that big, but in the interest of trying to further sharpen the space of disagreement, I think that focusing on the question of primacy is really helpful, because taking on board the way that Mike has framed the task of interpretation, I think I am probably more on the side of what you're describing as liquidation, what Dworkin described as best fit, than I am on the side of originalism, the starting point. And I would even say that perhaps emphasizing where we begin, rather than the way in which these institutions evolve and get interpreted, is to misweight the inquiry. It puts the cart before the horse. Because the tradition of practice that can grow up around constitutional provisions can become so much thicker so quickly as compared to wherever we began, as to render, at least in some cases, that original meaning, if not irrelevant, at the very least only a very small component. The West Virginia example is the one I'm going to stick with just for the sake of illustrating things, right? The simple fact is that West Virginia is a state. The idea that West Virginia is unconstitutional is simply incoherent. And yet, it doesn't matter from that perspective what the Constitution has to say on the subject, right? If it were to turn out that the existence of West Virginia is incompatible with the original meaning of the provisions around creating states, we just wouldn't care. So that tells me something about the meaning of the Constitution. Whether it tells me that the practice that has grown up around West Virginia is so thick that whatever the provision might have meant at the beginning, it just swamps it, or whether it tells me that we don't care about the original meaning in this case, I don't know, man, that's kind of a semantic debate. But at the very least, it illustrates that when it comes to that constitutional question, trying to ascertain the original meaning of the Constitution is the wrong inquiry. Okay, is more of the Constitution, are more of the constitutional debates that come before courts like the constitutionality of the existence of West Virginia, or about the meaning of the Free Exercise Clause? I don't know, right? That's a genuinely hard question. And I do think that as an advocate, you want to use all the tools at your disposal. When I think about my own approach to reading provisions of written texts, I do always begin, if I can, with what they meant at the time they were enacted. And then I try to trace, well, what happened after that? Because if I can reconstruct that history, then I will feel like I'm on solid footing when I'm making arguments about those provisions. But that's not true about every provision. And if you get the history in front of the function of the provision, you will sometimes end up making dumb arguments. So if you walk into court and say, I can't find the moment West Virginia became constitutional, thus it's unconstitutional, that's a dumb argument. You will be embarrassing yourself and the other arguments you make. Okay, what if I go into court and I say an original interpretation of a provision requires that the United States government no longer be able to function? Well, there are some claims like that might once upon a time have been obviously dumb. When you have a revolutionary judiciary, that may actually be less delegitimizing, right? You may be able to frame certain arguments that might have appeared radical, but that now you can find a court that will go along with them. But again, right, if you're thinking about this as an advocate, the thing you need to know isn't, can I come up with a plausible originalist argument for this proposition? It's, is this claim so beyond the pale that it will get me laughed out of court or not? And that consideration, I think, isn't really about originalism at all. It's not just about politics. It's not just about taking a Ronald Dworkin, make the Constitution the best it can be, best light. It's something about street sense of the law. Dylan Penningroth, a great legal historian at Berkeley, has a fantastic new book about the Black American experience with the law before the Civil Rights Movement, called Before the Movement. And he describes how Black Americans developed what he called a goat sense about the law. You got to know what you can get away with and where the law will go. That sense is in part about how we live together, right? It's part of the sensibility you're developing as lawyers. And I think that sense actually does more for the meaning of the Constitution than the original meaning at the time it was enacted.
West Virginia. We could, my co-casebook author, Michael Paulson, wrote a wonderful law review article called Is West Virginia Constitutional? He's more of a originalist than I am, and his answer was, there's a perfectly good originalist argument. I'd be happy to but nobody's interested in West Virginia. And I want to take Noah's point more
I'm sitting
seriously
right here, Mike.
than that. I think he's saying that there's some things that are just a fait accompli, right? And nobody's going to change them. I think paper money is probably an example of that. I'm not sure whether it was constitutional or not, but frankly, nobody brings it up anymore. Faits accompli, is that the right plural? Faits accompli don't come up in court because they're faits accompli. Nobody's raised the legitimacy of West Virginia in 150 years. I'm not particularly worried about faits accompli. What I'm interested in, but I want to say goat sense, I never heard that term before. I like it, and I recognize it. This is the way real lawyers operate. This is the way real originalist lawyers operate. But it's like, how far can you go? I started litigating in the area of the religion clauses in the early 1980s, and it took 30 years before the Supreme Court began deciding, or before the court ended up in a place that is pretty close to what I've been urging all along. But I didn't leap ahead 30 years. I tried to use goat sense, even though I didn't know what it was at the time. And of course lawyers make arguments that are that the system can swallow. And of course judges who are part of a system do that, but you have to know where are you headed? Goat sense is you take things as far as you can. You push the envelope at a certain point. You need to know what the direction is. And my aspiration for constitutional law is to have it look a little bit more like what the document looks like, and a little less like what the Warren and Burger courts imagined that they wanted it to look like. So that's my aspiration. By all means, let's use goat sense as a way of getting there, but I'd like to know, but we need to have a sense of where we're heading, and that's what I think originalism does. But just one last point on this, is that sometimes the faits accompli need to be overturned. Not West Virginia, I don't think. Perfectly nice place as far as I'm concerned. But how about things like segregation? Or how about the idea that private schools could not receive their equal share of government funding if they had a religious affiliation? These were things which looked like faits accompli at one time, and they are no longer faits accompli. So, but how does it work? There's a certain division of labor within the legal community where I think it's the job of law professors to have a little less goat sense, maybe, to be a little bit more interested in getting the answer right, even if it's a little jarring at first, to enlarge the Overton window so that we can consider other possibilities. And very frequently, reform comes in the form of dialing things back to the way they originally were. Now, one of my articles is on segregation, and I don't know how many people have read it, probably very few, but I showed, to my satisfaction, not very many other people's, but to my satisfaction, that large majorities of both houses of Congress in the years immediately after the passage of the 14th Amendment, never 2/3, but large majorities repeatedly voted for legislation that they understood explicitly to be enforcing the 14th Amendment, that outlawed segregation in the public schools, and they explicitly, at least 4 times, voted down separate but equal alternatives, right? So that's the history, and I like that history a whole lot better than what started off in the 1870s and 1880s. Plessy versus Ferguson, when it was decided, was a new thing, And originalism is a very valuable tool for us to rethink the path dependence that is sometimes leads us to a bad place. By the way, not just in law, but in life as well.
So as ever, I find so much in what Mike's saying that I agree with and that's really illuminating. Let me just start with the faits accomplis and just move a little bit through. I wouldn't describe them just as faits accomplis for the reason you said at the very end, which is that things that seem like settled arrangements or settled social facts can turn out to be things that we can destabilize. Mike says no one's challenging the constitutionality of West Virginia in court. I say, guys, that's only until it becomes politically convenient to do so and you think you can win. There's a lot of stuff that hasn't been challenged in court until you can see a politically useful strategy to do so, when it turns out that the votes for West Virginia...
I recommend it to Democrats, by the way.
Yeah. It could have been a useful thing to do at some times when the West Virginia votes weren't going the way you might have wanted them to, right? So that's the anxiety there. But where we are, again, totally on the same page is that social facts can become destabilized, and then we have to figure out how do we adjudicate conflicts over them, right? So the question of whether originalism provides a good gauge for where we're headed is, I think, another place where Mike and I can draw a sharp disagreement. So I very much agree with Mike that looking to the past can be incredibly illuminating for understanding how where we've wound up today is a function of path-dependent choices that could be otherwise. The past can be an incredible resource for understanding how things about the present can be different and for developing alternative strategies. But the key point for me, and I think this is a disagreement with Mike, is that for me the way the past does that is not through a return to the binding authoritative past. It's rather looking to the past to understand how it informed the present and uncover the places where decisions have been made, which then can free us to think about whether those decisions could have come out differently and what it would take for those decisions to be different. Mike's article is fantastic, but to me the persuasive force of the article doesn't come from the fact that the original meaning of the 14th Amendment was not to endorse separate but equal. Rather, it comes from the fact that we can develop an argument for racial equality that we can then reconcile with aspects from an original moment. The thing that is leading is not the original meaning of the text, but rather our sense of what it means to live together. To take a different example, right, the meaning of the 19th Amendment, now the 19th Amendment is incredibly restricted, right? The 19th Amendment just grants the right to vote without regard to sex. But there's a wonderful article by Reva Siegel, She the People. She looks at how the 19th Amendment was originally interpreted. And one of her arguments was just that the 19th Amendment gave political equality without regard to sex. Political rights were understood to be the most important. They come after economic, social, and civil rights, which means that I guess women must have had equal civil rights too. And sure enough, judges relied on the 19th Amendment to strike down special protections for women that existed on the grounds that women were more vulnerable in the workforce and things like that. On the flip side, if women have equal civil rights, then that should mean that the 19th Amendment enacts something like the Equal Rights Amendment. Okay, people don't buy this argument. You might not buy this argument, but I submit to you that whether that argument is right or not is not a function of the original meaning of the 19th Amendment, but of what we think about equality now. And we appeal to the history in order to ground those arguments. Does this mean that I am at the mercy of judges doing whatever they want, and that it would be better if we went back to the original written Constitution? I don't think so, right? The original written Constitution can bind as a written document. It can provide a site for coordination. It can set up certain sorts of structures. Jack Balkin, in his book Living Originalism, distinguishes between provisions that are hardwired in and don't leave a lot of room for interpretation, and provisions in which you sort of set in motion processes by which we, as a discursive community, interpret the document. So the document can do a ton of work for us in binding us, even if we do more than read it through its original meaning. And on the flip side, if the goal of the Constitution was to create a government of limited powers that was also flourishing, I have greater confidence in the complex social processes in which adjudication is one moment in the elaboration of constitutional meaning than I do in what I think the vision Mike is laying out, which is that we should have the Constitution mean only what it meant at the time that it was written, insofar as that meaning is clear and binding, and leave everything else to some sort of indeterminate democratic process.
So now I can put my finger on one word that Noah uttered twice that I think has a lot to do with our disagreement, and that word is we. Because what he said was that it isn't that we should care, what the original meaning was so much, don't ignore it altogether, but don't put too much weight on it, but instead we look to what we think equality demands or what we think is the way in which to live together. Now, there are some issues that everybody in the room agrees upon, and so as a rhetorical matter, it's really easy to appeal to those. But as cases of serious weight come to the Supreme Court today, they are not cases where everybody in the room agrees. They're cases in which Americans of good sense and moral judgment can be found on both sides. I think abortion is a great example of this, but it's not the only one. There are a number of people who believe, for example, that the president should have much more substantial authority to act unilaterally in a number of areas than I think. So, for example, I thought that when President Obama decided to engage in an eight or 9 month air war against Libya, that was not consistent with the original allocation of war-making authority between the president and Congress. But lots of people thought so. I mean, I don't remember Obama becoming massively unpopular as a result of that. Some people think it's a really good idea for President Trump to be able to announce tariffs unilaterally. And we could go through a number. Affirmative action has people on both sides of the issues. Sometimes there's an issue that used to be very controversial and isn't so much anymore. I think basic women's equality with respect to civil rights is kind of behind us, but sometimes they're not. Sometimes the court decides something and it doesn't accord. But the thing is, there isn't a we. And it's the job of the courts to adjudicate between two different, sometimes quite conflicting, reasonable we's. And what's going to be the basis for deciding between them? When push comes to shove in this country, even liberal Democrats who might not claim to be originalists tend to turn to the original meaning in order to resolve important issues of constitutional law. I think, for example, of the impeachment proceedings against Mr. Trump. The Democrats were the ones who were constantly citing the original sources having to do with what the impeachment clause meant. And they didn't do that because we have any particular opinion about this. We were divided, but when we are divided on an issue that the Constitution speaks to, it is the American tradition, and I think a good one, to look back to what its original meaning was.
So this is incredibly helpful because I do think this gets to the nub of our disagreement, where I completely agree with Mike that an absolutely critical question is how does the law handle profound disagreement? And I'll go one further, which is that I think one really distinctive thing about the American legal culture and legal tradition is that we, more than almost any other country, are committed to the idea that we can have a polity bounded by law with people who truly, profoundly disagree, who genuinely think that their neighbors are going to hell, right? Who don't believe that the people they live next to have the same claim on their society as they do. And nevertheless, we are going to live in polity together. That's a remarkable claim and proposition. And if you want to do that kind of liberalism, right, that's a liberal claim, you're going to need a really unusual law to do it. I think where Mike and I disagree is about whether, when it comes to those profound disagreements, what leads to whatever small degree of genuine settlement we can get comes from the original meaning of the Constitution or something else. And I think my take is that appealing to the original meaning of the Constitution doesn't actually provide that settlement, and where we have decisions that are accepted on the basis and that involve such appeals, it's not those appeals that are doing the work for us. So when we consider some of the leading originalist cases of the last few terms, Bruin was brought up, think about Dobbs, or cast your minds back to Heller. The fact that those arguments are built around appeals to original meaning has not made those decisions any less controversial. Just the opposite. I think many people look at the appeal to originalism in those cases and say, you are trying to get around the hard question, and you're using an appeal to the original meaning of the Constitution to advance what are basically political policy preferences. On the flip side, right, courts can, it's hard, but they can try to manage profound disagreement. It would be insane if a court could settle profound disagreements, right? If I believe that Jewish people, I'm Jewish myself, if I believe that Jewish people should not be in my community, right, is a court decision going to get me to change my mind about that? Right? All that the court decision could do, presumably, is make it possible for me and my children to exist with some degree of, I don't have children yet, I hope to have children. I don't want, this is rhetorical posture, but I want to communicate the point, right? For me and my sister, I have a sister, I have a brother, I have a niece, they're all coming for Thanksgiving, it's going to be lovely. Okay, for us to exist with some degree of security, certainty, harmony, fellowship, recognizing the fundamental bounds of disagreement. And I think that the things that make a decision work, legitimacy, practicability, efficiency, toleration, right? Those might be connected to the original meaning, but they don't have to be. And it's not the original meaning that's going to make a decision like that stick.
Before talking about this point, I'd like to drop a footnote about Noah's statement about this being a country in which people are able to live together despite profound disagreements is something on which we profoundly agree, but it is, I think, my footnote is, I worry that it is actually, we're on the edge right now. I don't think we've plunged into the abyss, but we're on the edge, and this is my sermon. I'm not Jewish, but pretend I'm your rabbi. This is a sermon to you. Please do your best not, to keep yourselves and our fellow citizens from going down this road, because the accusation that the other side is not just wrong, but illegitimate and conspiratorial and evil that way be dragons. It's really unfortunate, and the courts have been engulfed with this. I would have said a couple of years ago that it was primarily the left that was like trying to delegitimize the court, especially in the wake of Dobbs. We have somebody trying to assassinate Brett Kavanaugh. We've had other judges more recently killed. Now it seems to be that the right is as bad or worse in terms of delegitimizing the courts. And end of sermon. I just really think that this is possibly much more important than originalism. Now where were we?
Whether appeals to original meaning are going to be the way to resolve these profound disagreements.
So the nice thing about the Constitution And I think if we have a constitution, that's really the way to read it, is like we don't want to just pour, unrelated stuff into it, and I don't think Noah disagrees with that. The nice thing about a constitution is it does give us an agreed upon starting point. And when we can't, if we were to try to debate something like, what are the grounds for getting rid of a president? It's going to be, we're going to disagree. We don't have any basis for judgment. There's going to be people who like Trump are going to say one thing, people who don't, and everybody will switch sides from how they answered the same questions under Bill Clinton's impeachment, and it's just, and it is really a wonderful aspect of our system that there is something out there that that's before politics, and that we are all able to appeal to. So I actually think that Noah is empirically not correct about this. I think empirically an appeal to the Constitution, and I think that has to mean something like, some version of originalism is the most specific way in cases where we have no other basis for agreement. And again, I appeal to the fact that when push comes to shove in major controversies in this country, both sides seem to do this. And look at Supreme Court confirmation hearings. Forget about the Republicans who all claim to be original, or some do and some don't. Forget about them for just a moment and just look at the Democratic nominees. Look back, if you don't want to do all of them, look at Justice Jackson. Justice Jackson began her confirmation hearing by saying, I'm not going to judge according to my personal views, I'm going to judge, and she specifically referred to original public meaning. She sounded like Robert Bork. He would not have said anything different in the first half day of the hearing. Now, why is that? I don't know anything about her. I've never met her personally. Don't know what she really thinks about things. But what I do know is that she's smart enough to appeal to something that she thought would be common ground, right? And so this is evidence that someone, on the progressive left believes that original public meaning is common ground in America. And common ground is something that it's not just right, but it actually is, I think it serves the functional purpose that Noah is referring to as being something that rallies people around. And I think of Brown versus Board of Education. Surely, along with maybe Roe, the most contentious. And when you look, and as I have looked at what the Southerners, the Southern opponents of Brown said, is that they accused it of social engineering, and the smart ones pointed to that footnote, is it 11, where the court cites supposed social science evidence that turns out to have been bogus, and how much better it would have been if the court had been able to say, whatever you may think, this is what those who added the 14th Amendment to the Constitution thought. I think it would have been, who knows, this is counter-historical.
But this is great, and maybe we can move to questions, because I do think this kind of sums up the disagreement nicely, which is we agree on the importance of finding ways through law to work through or manage profound disagreements. I think we agree on the fact that a written constitution provides a starting point. Maybe we disagree about exactly how much. I might say that our constitutional culture is broader, so there are other starting points too. We don't talk as much about Magna Carta right now, but it has to do with the particular kinds of claims that you might make. I think where we disagree, though, is that if you say that you're going to use the written constitution as a starting point, that commits you to originalism. And of course, Mike, like I said, this is the most reasonable version, right? Some kind of originalism, taking originalism into account. At no point has Mike ever said, the original meaning of the Constitution on every question we might ask of it is knowable, determinate, and will be binding, which is like, great, right? So we're talking about a pretty small number of cases that we might actually be sort of looking at together, where the disagreement might be over what we do there, but for the sake of this conversation, I want to sharpen the disagreement and say, I'm not even sure that even there, the original meaning of the Constitution, where ascertainable and speaking to the question we ask of it, is binding in the way that solves the questions we need it to solve. And Brown v. Board of Education is a nice example, right? It's counterfactual history. As a legal historian, this is a dangerous thing to do, but I'm pretty confident that we would have had massive resistance in the South to the integration mandate in Brown, regardless of what that opinion said. The most important part of the Brown v. Board of Education decision is not footnote 11, which is bunk and crazy. It's not the apparent fundamental right to education, which Warren refers to and which never gets taken up again. And it wouldn't have been any better if it was grounded in the original meaning of the Equal Protection Clause. What matters about Brown is that it was unanimous. And that tells us something about the place of the court and the Constitution in politics. It's part of our legal culture to act as if the Constitution comes before politics. But that's not true. The Constitution is part of politics, and the meaning of the Constitution is worked out through political contestation. I would say that the challenge, and this is, now I'm on my little soapbox, right? The challenge from a social theoretical perspective is the challenge that Mike and I have been grappling with. It's how do you pacifically resolve profound disagreements? And constitutionalism and our constitutional culture provides a way of doing that for the most part, as long as, and again, I totally agree with Mike on this one, we remain committed to that project, which requires recommitment. Of course, it involves appeals to hallowed ancestors, to profound authority, to historical tradition. All of that can look an awful lot like originalism. Nobody liked to cite the founders more than William Brennan, right? The great champion of living constitutionalism, who allegedly is a profound anti-originalist. But he knew that when you can ground your constitutional argument in the words of the framers and make it appear to be part of an unchanging continuous tradition, that makes it a lot more compelling. But I think where Mike and I really disagree is that I think the kind of binding force comes from the fact that it is compelling, comes from the work that it does. Whereas, and I don't want to put words in Mike's mouth, but it sounds like he's more bullish on the idea that the original meaning of the document, where ascertainable, can be the thing that helps us resolve those disagreements.
Ready to take questions? Okay, great. So please line up here, and we'll alternate between sides. Jonah, why don't you get started?
Great. So I want to take up your point about Brown v. Board, because I disagree with it strongly that the most important thing was its unanimity. I think that Brown v. Board essentially said Plessy v. Ferguson was not wrong in saying that the 14th Amendment protected political rights and not social rights, but then through this sort of bunk social science, they said education is a political right. I don't think it is, but I think that, you know, per the dissent in Plessy, the 14th Amendment was intended to cover both. And I think if the Supreme Court had said the 14th Amendment covers both political rights and social rights, we'd have a much broader degree of rights protection than we have now. So I think they actually sort of squandered a huge chance to more widely and holistically protect our rights in the name of sort of getting unanimity and capturing the social momentum of the era. And I think that we're seeing a lot of consequences of that now. So you know, how do you argue that the unanimity has provided more value than a firm grounding in the Constitution that would have expanded our rights would have?
So I love the rights-based arguments. I think there's a question I'm a little fuzzy on, so this is a question for you. When you say this, do you mean that it would have done more in the law, or it would have done more in the world?
Well, I think both. I think that it would have, instead of having to say, okay, we're going to reclassify this social right as a political right through empirical evidence or social science, it would have just instantly sort of lit up all of our social rights with constitutional protection. I think that's a much more sort of scalable and rights-affirming verdict than this sort of forced transition of a social right into a political one.
So I don't disagree with you that from a jurisprudential perspective, there's a lot to recommend the argument you're laying out. I think the anxiety that I have is that after Brown, Prince George's County decides to shut down their education system rather than have to educate white students and black students beside each other. After Brown, when the question of whether anti-miscegenation laws are constitutional, the Supreme Court decides that it's so toxic a subject that they kick it away several years, even though it's obviously unconstitutional even under the prior decision. After Brown, even Frankfurter, who is by no means a right-wing reactionary, becomes so anxious about the extent to which the court is now involved with some of the deepest issues of social organization that he becomes aggressive in demanding that the court distance itself from doing anything that might even hint at putting the federal government in the line of fire protecting the rights of non-white Americans. So from the pure world perspective, my anxiety is that if the Brown ruling had been broader and put the rights of people of color on a stronger foundation outside of education, it wouldn't have had the jurisprudential effect that I think we agree on. It would have had the actual historical political effect of delegitimizing the court and of leading to the massive resistance that we saw on an even wider scale. And my claim for that is simply that the narrower ruling led to such massive resistance that it stands to reason that a wider ruling would have occasioned at least as much resistance or more. The reason why I think the unanimity is so important is because of what it did for the way in which subsequent cases get litigated and what it signals. So if you have an 8-1 decision or a 7-2 decision, it's clear what the law means, right? Your position is fringe. But you are inviting people to continue to make and elaborate that fringe argument. You know that you got at least one vote. Think about Morrison v. Olson, right? When Scalia writes his dissent, it's a solo dissent. Even Rehnquist says, my brother, you're trying to put more on the words than the text will bear. You're insane, take your marbles and go home. But you know that you're always going to get at least one vote. You're never going to be laughed out of court for making a frivolous argument. Your claim is at least getting a reception at the Supreme Court. And sure enough, right, unitary executive arguments building on Scalia's dissent continue to proliferate. By contrast, a unanimous decision says, go home, you're drunk, right? And so after Brown v. Board, every case advancing the kind of Plessy v. Ferguson segregationist arguments gets struck down. Doesn't matter what the foundation is, you know that you're going to lose. And while that is more incremental in changing legal culture, and ultimately ineffectual, right? Schools are more segregated now than they were at the time Brown was decided. It actually, insofar as you can make change through the courts, that does seem to be the way that you can do it.
Can I just, I would like to make a completely non-originalist point, but I have to say I was a little surprised. I didn't know what was going to come out of your mouth when you said what really mattered in Brown was. And unanimity is not actually, would not have been in like my top 5. I think there are a lot of things. Number one is because we had President Dwight David Eisenhower, who believed in the rule of law, and even though he didn't agree with Brown, he sent in the troops to Little Rock, Arkansas, and enforced it. That's what made it stick. And then the fact that Congress in 1964 put the financial muscle of Congress behind Title VI. That's why Brown worked. Brown didn't actually work. Just as a decision.
No, I'm not. I don't actually disagree. Right? I was thinking within the confines of the decision.
That's not an originalist point, by the way. That's what Noah should have said.
Yeah. Why don't you introduce yourself and
Thank you both for being here. My name is Jeremy. I am a student in Professor Rosenblum's class. First, a question for him. Will there be cookies in class tomorrow to celebrate your tenure?
Are you bringing them is his question.
I would be happy to.
I invite you to bring them. He shouldn't have to bring cookies to his own party.
It's a deal.
Thank you, Mike.
Question number 2. This is for both of you. In Professor Rosenblum's class, we've talked about some of the kind of splintering of different forms of originalism, different schools of thought, but also some of the intellectual movements that are now either pushing back on or replacing originalism. For example, Adrian Vermeule's push for common good constitutionalism. And I'm curious to hear your thoughts as to what you see as a judicial or more academic philosophy as kind of the next thing that might be what we're talking about in 20 years in this kind of context.
Was that put to me?
That's put to both of you.
Every year I go to a conference called the Originalism Works in Progress Conference in San Diego. It's by far the most intellectually stimulating academic conference I go to most years. Everyone there is either, well, actually, there are quite a few anti-originalists there, but everybody there believes that originalism is a very important question for interpretation. Some of the papers are on applying originalist methods to various issues. A lot of them, though, are on these issues of methodology, where there is a great deal of disagreement. And I have to say, I find much of this to be nitpicky and not very helpful. And it is my hope that we return to a kind of, I didn't really mean to give a label, common sense originalism. I just used the term in its ordinary sense, something like that. I don't know if any of you read C.S. Lewis, but there's all this theological debate about niceties of this and niceties of that, and he wrote the most important tract in Christian apologetics in the last 100 years called Mere Christianity. So, I think I'm for mere originalism, and my guess is that that's probably what we'll return to, but right now there's enormous ferment, and a lot of it is kind of silly, in my opinion. A lot of it is done by people who actually haven't delved into the historical record enough to know how the arguments actually play out when you're trying to do it in practice.
My only take would just be that originalism, I think, historically developed and was pushed as a way to limit what judges could do. That's certainly how Scalia understood it, and the first kind of iteration of academic originalism, which took a very linguistic approach, was built around this idea of fixation. Lawrence Solom has a famous article, The Fixation Thesis. This is a useful project if you're unhappy with making change through the courts. But if you want to make change through the courts, that's a bad project because you need something that will leave judges with more flexibility rather than less. The latest versions of originalism, original law originalism, are remarkable for the way in which they seem to reject many of the claims about fixity that some of the earlier theories laid out. And I wouldn't be surprised if 20 years from now, assuming that the courts continue to maintain the kind of cast that they're getting, and that we see the people doing originalism interested in using the courts to make change rather than to frustrate change, if we're not going to see more theories like original law originalism that actually loosen the shackles on judges in the name of originalism as a brand rather than the opposite.
And it wouldn't surprise me, assuming that the courts continue in a kind of conservative complexion, if the left doesn't adopt something like old-fashioned originalism, which seems to me to be a pretty good defense move. If I didn't trust the political instincts of the judges, I would say tie them down.
Okay, I think we have time for one last question.
Wonderful. My question, I think, goes right to the heart of that issue you two were just discussing, and thank you both again for being here. I think it's mainly posed to Professor Rosenblum. So if primacy in constitutional analysis goes to our theories of justice and equality under the law, which is then accommodated to the history of the text, I worry about what to me seems to be kind of an absence of a limiting principle. Let me pose a hypothetical. Let's say President Trump fills the judiciary with judges ideologically aligned with him, or even that he packs the Supreme Court. Does it worry you that they could follow what seems to be my understanding of your analytical process to ends that you would diametrically oppose? Can you maybe speak a bit more to why judges in the judiciary, rather than other Republican institutions, are the ones best suited to determining these appropriate theories of justice and equality?
So the am I worried? The answer is not only am I worried, but how could I not be? Let me flip it around. Would I really expect a written constitution to prevent a bunch of ideological judges appointed to their position for political reasons, whether on the left or the right, to stop them from realizing their political purpose, it would be a remarkable political technology that had the ability to prevent someone who was selected for their position because of their politics, confirmed by a partisan political institution to accomplish a partisan political goal, to not be able to do it. And case in point, right, I'm a legal historian by training, think about the history of abortion, right? So Roe v. Wade is decided, you have a conservative legal movement that makes one of its really central goals overturning Roe v. Wade. They get a majority of appointees with Casey. The judges do not overturn Roe v. Wade. We get Casey. What's the response? The response isn't amend the Constitution. The response isn't, change how courts operate. The response is, oh, well, we screwed up with those judges. Let's get some other judges who will be able to read the constitutional provision in the way that will work for us. And they do, right? They don't change theories of interpretation, allegedly, right? They're no more or less originalist in Dobbs than they are in Casey. And yet, despite that, different outcome because of a political goal that they're focused on. So the question, my colleague, your professor Darrell Levinson, has a wonderful article about the puzzle of parchment barriers and when and why they're effective. So I think what we need to ask ourselves is, what do we expect of a constitution and how do we expect it to be operationalized? If I thought judicial interpretation alone were enough to provide the constraints, I might have a different approach. But I think that position is naive. So when I say I think questions of justice are actually coming first and the meaning is coming second, I don't mean that normatively. I don't think that's good or bad. I mean that descriptively. I think that is how our Constitution operates. And so, as a future lawyer, it behooves you to understand that so that you can learn to argue for your client. I think to wish it otherwise is idealism that is disconnected from the reality of law and political institutions in a way that no one would have been more contemptuous of than our framers, who were practical political men and understood that you had to design institutions to achieve certain goals, not wish them to be a certain way.
Well, on that note, please join me in thanking Professors McConnell and Rosenblum.